Calendar for the day. The first bill on the calendar for the day is House File 10. The clerk will report the bill.
House File number 10, number 1 on the calendar for the day, an act relating to human rights.
I recognize the member from Ramsey, Representative Moeller, to your bill.
Thank you, Madam Speaker and members. House File 10 is the sexual harassment bill that would help keep Minnesotans safe from sexual harassment in the workplace. House File 10 is the same bill that was authored by Majority Leader Pepin last year, the bill that many of you co-authored, and that the vast majority of you who were here last year supported. This bill is necessary to ensure that workers are safe in their workplaces. The Me Too movement has given a powerful voice to survivors and has highlighted that we need to change workplace behavior. Last year, this bill that you supported originated as a result of the testimony that Representative Pepin and committee members heard in the Harassment and Workplace Committee. What we're trying to do here, and what you did last year when you voted for this bill, is to return the law to what it was when the legislature enacted it in 1982. Although it's not in our statute, the courts have inserted the severe or pervasive requirement into our statute. In Minnesota, that has meant that victims have not received their day in court, but instead have had their claims rejected on summary judgment. Severe or pervasive is such a high bar that things like unwanted kissing, unwanted touching, requesting oral sex, and comparing female employees' breasts are not considered severe or pervasive in our state. These facts are all from Minnesota cases where summary judgment was granted to the employer, so victims were denied justice. And of course, we don't even know the number of victims who were told that their case shouldn't proceed because they'd never be able to satisfy the severe pervasive standard. I'd like to quote the Minnesota Post article, a quote from Representative Pepin last year. She said about the committee, lawyers talked about how they would have potential clients and they would outright tell their clients, well, this isn't enough. This is not going to even be a case. The severe or pervasive level makes it nearly impossible, if not impossible. We were pretty shocked by some of the cases that we read of harassing behavior that happened, and there was no opportunity for someone to have their day in court. This session, House File 10 passed unanimously in the Judiciary Committee. And it was the same language that you heard last year, but based on concerns that were expressed in the committee, I worked with stakeholders to amend the language and to make this bill even better.
There's an amendment at the desk. The clerk will report the amendment.
Moeller moves to amend House File number 10 as follows, and the amendment is coded DE3.
Representative Moeller.
Thank you, Madam Speaker and members. So as I mentioned, we heard in the committee some concerns that were expressed about the bill as it was drafted, as it was written. And those concerns included, first, the use of the word offensive in the statute. And there were concerns about whether one joke an employee heard would then somehow lead to the result of a sexual harassment claim. Another concern that we heard was that by eliminating the severe or pervasive standard that the courts applied, we might also be eliminating other court standards like the totality of the circumstances test or the reasonable person standard. And so first I want to thank Representatives Robbins, O'Neill, and Scott for suggesting language to me that they felt would address some of these concerns. And in addition, many proponents and I reached out to others who had concerns about the original language in an effort to improve upon this bill. And some of them, like the League of Minnesota Cities, responded. So this amendment that you have before you today is the result of many different drafts and discussions. This amendment also addresses the concerns that were raised regarding the original language. So if you look at the amendment, you'll see that we've added the word materially before offensive, and that's in order to address the concern about one joke leading to a sexual harassment claim. So with this amendment, sexual harassment is now defined as, it would be defined as unwelcome sexual advances, requests for sexual favors, sexually motivated physical contact or other verbal or physical conduct or communication of a sexual nature when it has the purpose or effect of creating an intimidating, hostile, or materially offensive environment. So we made clear that in determining whether there is an intimidating, hostile, or materially offensive environment, the finder of fact must apply both an objective and a subjective test. So in other words, would a reasonable person in a similar situation as the plaintiff feel that the environment is intimidating, hostile, or materially offensive, and that the plaintiff in fact subjectively felt it was so. We further clarified that this determination is based on the totality of the circumstances. So members, this is compromise language that addresses the concerns raised at the hearing and still ensures that Minnesota's workers will not have to endure sexual harassment. I hope you will support the amendment.
There's an amendment to the amendment. The clerk will report the amendment.
Scott moves to amend the Mueller amendment to House File Number 10 as follows, and the amendment to the amendment is coded A8.
The member from Anoka, Representative Scott, to your amendment.
Thank you, Madam Chair. And this amendment addresses one of the concerns that we had in committee, and that was the concern over the word or versus the word and. And we believed that having particularly a word that's a disjunctive like or rather than a conjunctive as an and, particularly as it relates to that word's offensive, was probably too broad. And so what this amendment does, the amendment to the amendment, is it substitutes the word or for the word and removes the word materially, because I think if you put the word and in there, you don't need the word materially. And so I would ask for for members' support on the amendment, and I'd ask for a roll call, please, Madam Chair.
Representative Scott requests a roll call. Seeing 15 hands, there will be a roll call. Discussion to the amendment. Representative Moeller.
Thank you, Madam Speaker. And Representative Scott, while I do appreciate your work on the language in this bill, this is not an amendment I can support. By requiring that the environment be intimidating, hostile, and offensive, I'm concerned that courts will require either physical abuse or threats of physical abuse, and that some conduct that should be considered sexual harassment will be excluded by that language because the conduct will not necessarily satisfy all three requirements. So, for example, I was thinking of a situation where perhaps an employee who was maybe small in size was flashing a larger coworker. That conduct is certainly offensive, but it might not be intimidating based on the size differential between the two. Keeping the word materially as a modifier to the offensive environment strikes a better balance at addressing the concerns you have while also making sure that Minnesotans are safe at work. So members, because this amendment to the amendment is too restrictive, I would recommend a no vote.
Discussion. Representative Scott.
Thank you, Madam Chair. And would the bill's author yield to a question?
She will yield. Representative Scott.
Thank you, Madam Chair. And Representative Moeller, could you define materially for us?
Representative Moeller.
Thank you, Madam Chair and Representative Scott. So materially is used in the context of the Department of Human Rights Act, or the Human Rights Act, with respect to ADA claims. It's a word that's commonly used in the legal arena, and if there's not a specific definition, then courts will look to the dictionary definition. It's a word of common usage.
Representative Scott.
Thank you, Madam Speaker. And that's one of the reasons that I had concerns over this, because there's really no definition for materially. And even if it's in the ADA, that's a different set of circumstances, and I'm not even sure how it applies in the ADA. And that was my concern and why I drafted this amendment, because I'm not really sure what materially means and how it modifies the word offensive. I don't know if anyone else has any input here on the floor as to what that might mean. There are other lawyers here I know, but that could maybe help out. But that was my concern, and so for that reason, members, I'd ask for a green vote on the amendment to the amendment. Thank you, Madam Speaker.
Any further discussion on the amendment to the amendment? Seeing none, the clerk will take the roll. The clerk will close the roll. There being 52 ayes and 72 nays, the motion does not prevail. The amendment to the amendment is not adopted. Discussion on the underlying Moeller amendment. Seeing none, all those in favor say aye. Those opposed say no. The motion prevails. The amendment is adopted. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File Number 10, as amended.
Third reading as amended. Discussion to the bill. The member from Anoka, Representative Runbeck.
Thank you, Madam Chair. I have some just general comments to make. I should confess, I've been in the workplace for almost 50 years. I was there before the Human Rights Act, during the rolling out of the Human Rights Act, and now as it has become a more mature piece of law, I've been there. I've seen how it has changed the workplace, and certainly any of you who have been there too, you've seen how much has changed, how much more sensitive everyone is to issues of sexual harassment. In fact, perhaps the pendulum has swung too far. And I'm just going to make the statement that I believe that our employer community will do anything to avoid a sexual harassment case and to be labeled that there is some sexual harassment going on to the point where they are not considering the potential harm done to the person who's being accused, often who are men, and sometimes young men, sometimes naive and vulnerable men. And I just spoke today with parents of a young man who is on the obsessive compulsive and autistic syndrome. He's not doing well reading some of the social cues in his environment. And he was told by his employer that he offended a woman manager in his company, that she felt uncomfortable with him and around him. He was told, do not contact her, do not look at her, do not touch her. And he could not get them to investigate and to find out more about what this complaint was. The young man was devastated. He spent a number of weeks in counseling, was told he probably had PTSD as a result of the damaging circumstances he found himself in, where nobody came to understand his situation. All I'm saying is that this law goes both ways, and perhaps as this has been interpreted over the last 4 decades, the pendulum has perhaps swung too far. And I would like to see a few added things to the bill, which we don't have now. We need an employer defense, because employers are taking the proper action in many cases. They are doing the right thing, and so they need to feel that there's going to be some impact and benefit from doing that. We should look at trying to find a way to allow for a situation where there's going to be a frivolous claim. I mean, you have the balance of power now completely one-sided. It's a one-sided interpretation of the law at this point, with employers so skittish, so nervous about having such a label put on them and placed on them. So I appreciate what the folks in the committee have done, and I thank them very much, and I thank the author for the adjustments that she has made as well. But we need a balanced law, members. If we are touching this law at all, which has served the country, not just Minnesota, but has served the country for the last 3+ decades, we need to advance and make a law that is balanced, that is going to serve and make our workplaces not the powder keg that it is, where every time you have a look, a look that might be considered by somebody to be a leer or a gawk. We can't have that. We've got to make it balanced. And so I would say that this is a great effort, but I'd like to see us go further and create a law that is balanced, that works for men and women, young and old, big employers, small employers. And members, I'm going to have to vote no. Thank you.
The member from Wright, Representative O'Neill.
Thank you, Madam Speaker. Well, I'd like to respectfully disagree with my colleague. So back in my 20s, I had a horrible boss, and I was unbelievably sexually harassed. I've talked about this in committee. Representative Mueller, you and I worked together on this and other things to defend women, to defend children from sexual violence and from sexual harassment. I want to thank you for your work. I want to thank you for listening to us and listening to our concerns. And I know that there's more work to do ahead. The Senate has a version, not a companion, but a version of this. And they have addressed some concerns that we haven't talked about in great length. And in light of that, I just have a couple quick clarifying questions, if you would yield.
Did you ask her to yield?
I did, Madam Speaker.
And I think she will. Representative O'Neill.
Thank you, Madam Speaker. Sorry to catch you off guard for a sec. Thank you, Representative Mueller. My question is pretty simple. The courts have held a long stand that they won't get involved in sort of a general civility code, you know, talking about inappropriate, rude, or offensive behavior. And can you just speak to if this makes any change to that longstanding kind of the law not getting involved in civility code and what this would do or not do? Thank you.
Representative Mueller.
Thank you, Madam Speaker, and thank you, Representative O'Neill. I have enjoyed working with you on a number of issues to protect women and children. So, yes, this is not going to change the law in that. You still have to have the unwelcome sexual advances, requests for sexual favors, sexually motivated physical contact, or other verbal or physical conduct or communication of a sexual nature that creates an intimidating, hostile, or materially offensive environment. So all of those things have to be read together. The court's not going to cherry pick out one word out of all of those things. They're going to look at all of those words in context. And by adding that word materially in, like we did with the amendment, I think we really wanted to address that this isn't trying to be some kind of civility code.
Representative O'Neill.
Thank you, Madam Speaker. And if the author would continue to yield.
She will. Representative O'Neill.
Thank you, Madam Speaker. We also talked a little bit, not at great length, but on the employer side, and we talked a little bit about them taking due care, and if they've been made aware of a situation, that they try to remedy that situation, and that kind of gets to the issue of liability. Just wondering if you could explain to the body, so where does that land now, an employer with liability, if they've made a good faith effort to try to mitigate that sexual harassment?
Representative Mueller.
Thank you, Madam Speaker, and thank you again, Representative O'Neill. Yes, we did talk about that in committee. The case law indicates that an employer who makes a reasonable response to a claim of sexual harassment is not liable. Nothing about our bill here changes that case law, because that case law doesn't have to do with the definition, which is what we're doing with this bill, is amending the definition of sexual harassment. So that case law still remains the same. So employers really can control their destiny here if they act reasonably in response to these claims.
Representative O'Neill.
Thank you, Madam Speaker. So with that, I really do appreciate that and getting that on the record and in front of the whole body, and I think that will help both sides make a very good decision today. I'm going to be supporting your bill today. It is better, I believe, than even when I was working with former Majority Leader Pepin, and we have come a long way. So I appreciate those steps, and I appreciate that effort, and I'd like to see that continue. And I know that the Senate has, like I said, not a companion, but a version, and so some of those things will be addressed there. But thank you, and I will be supporting you today.
Further discussion to the bill. The member from Hennepin, Representative Robbins.
Thank you, Madam Speaker. Thank you, Representative Mueller. I also enjoyed working with you on this, and I appreciate the many discussions we had and the opportunity to submit language for your consideration. And following up perhaps on what Representative O'Neill was talking about, she mentioned some of the employer case law and how that will still stand. I just wondered, the purpose of this is really to get rid of the severe and pervasive standard in Minnesota law. And so where the courts in Minnesota have made other statements regarding the standard for sexual harassment, will those still be considered authoritative? So when it's been in other cases, now that the severe pervasive will be gone, but the courts have made other statements about the standard, will that still stand? Thank you.
Representative Moeller.
Thank you, Madam Speaker, and thank you, Representative Robbins. So yes, and some of those statements had to do with the totality of the circumstances test, the reasonable person standard. And that is what we tried to address with the language here, just to make very clear that we didn't want to change any of those applications by the courts. We only wanted to remove severe or pervasive language.
Representative Scott.
Thank you, Madam Speaker. And I wanted to thank the bill's author for her work on this and for thanking former Representative and Majority Leader Pepin for her work as well on not only this particular issue, but her work in general on the Harassment and Workplace Task Force. And so I know this is not an easy issue to pick up and run with, especially as a freshman. So thank you, Representative Mueller, for being willing to do that. One of the issues, one of the things that we find when we've been around here for a while is issues that come back year after year. We learn more and more about them as we go. And I was a supporter of the initial language last year, and as we've learned more, I think there are still a few concerns that haven't been addressed. And one of the things that I think is important to point out with this issue is it doesn't apply just to employers. This applies to schools, higher ed, so think dormitories, housing, and any public place of public service. So I know one of the concerns I have is, I'm a landlord, and I'm very curious as to what my responsibilities and liabilities might be as a landlord going forward with this new language. Am I to be forthright, and do I have some sort of documents that I have my tenants sign? How will I operate, and how will I know if there's any sexual harassment going on amongst tenants? And so those are some of the concerns that I still have, and I still am not sure what materially really means. I'm glad to see some modifier in front of offensive, but I'm just not sure how strong of a modifier materially is. But I will be supporting this bill and look forward to you continuing to work on it with the Senate, and hopefully it'll come to be a really balanced, well thought out issue. Thank you, members.
Any further discussion to the bill? The member from Mille Lacs, Representative Erickson.
Thank you, Madam Speaker. And I just wanted the body to know that, I voted yes on this last year, but over the interim, I looked at all of the sexual harassment laws that have been enacted across the nation and those that were worked on particularly in the last couple of years. And I found them to have so much more specificity than ours does. And, as an English teacher, I really believe in specificity. And, the fact that we have vague language in this, even though I think that some would argue that this is specific, but even in our bullying bill, we had more specificity in regard to intimidation than we have in this proposal. So I want to wait to see what the Senate does, and also encourage members to really study what they've done in other states. Severe or pervasive has not been deleted. California has laid out very specific descriptions of what sexual harassment is. There's a long, long list if you want to look at their law. And I think that's what we need to provide for our employers, for our school employees, for local government employees, and for others throughout this nation who are dealing with this. Because we don't want to condone sexual harassment, but we also want our employees or others to know what is it that we're getting at when we say that there might be intimidation or there might be a hostile environment. So I really was pleased, even though I don't always agree with what California does, with the law that they came up with and what they have put into their statute, which I think provides much more specificity. So with that said, I'll be voting no today and waiting to see what the conference committee decides.
The member from Ramsey, Representative Becker-Finn.
Thank you, Madam Speaker. And I just want to acknowledge that this bill and this vote has been a long time coming. And wanted to thank Representative Mueller and Representative O'Neill and the others who've been working on this issue both inside and outside of the legislature for a long time. Also wanted to acknowledge that there There are people in all of our communities, both men and women, who have been impacted by this issue and by the way that the law is currently being enforced. And this vote is going to mean a lot to a lot of survivors and a lot of folks who are directly impacted in their day-to-day lives because of their inability to just do their jobs free of harassment. So I want to thank everyone who's put the work into this bill, and I'm looking forward to voting yes. Thank you.
The member from Hennepin, Representative Winkler.
Thank you, Madam Speaker and members. Thank you, Representative Moeller, for doing outstanding work and picking up the torch where Majority Leader Pepin left it for us last year. All Minnesotans deserve to work and live in an environment free from sexual harassment. That is why we are bringing this bill forward today. Over the years, case law has developed to treat situations which any one of us would consider to be sexual harassment, but it doesn't fall under the law, or at least the court's interpretation. This leaves victims helpless to get their day in court, and it deprives all of us of an opportunity to make sure that our workplaces are free from harassment. This is one of a number of bills on gender equality and gender violence that the House DFL is working on this year. The Equal Rights Amendment, requiring law enforcement to adopt policies for sexual assault investigation cases, a task force directed to rewrite the state's entire criminal sexual conduct statute, the marital rape exception, the task force on missing and murdered Indigenous women, Protect Access to Contraception Act, and much more. Over the last 2 years, the Me Too movement has changed the way we think about these issues. Women from all over the country and a good number of supporting men have stood up and said that we cannot tolerate sexual harassment anymore. Celebrities, politicians, CEOs, it doesn't matter who you are, nobody should be above accountability, and no victim should be beneath the law's protection. It is the courageous acts of everyday people who have changed this environment. The Me Too movement has also changed the Minnesota legislature. In the House, we've rewritten our policies around sexual harassment and now require mandatory training. 2 members of the legislature have resigned. Members and staff are required to undergo training on a much more consistent basis in the past, and I think all of us are much more aware of the environment in which we work and the effect that that has on people and the importance of keeping it free from harassment. I do specifically want to highlight the leadership of former Majority Leader Joyce Pepin at the end of last session. She stepped forward in a very difficult political environment, a very challenging environment last year, if we remember that time, and took a courageous leadership position. This House voted 121-4 to support her bill. And Representative Moeller's bill today enjoys even wider support amongst employers. So members, I hope that we can have an overwhelmingly strong vote on behalf of this bill. Thank you again to Representative Moeller for bringing this forward. And members, I would urge all of us to put forward a green vote today and stop harassment in Minnesota.
The member from Ramsey, the author of the bill, Representative Moeller.
Thank you, Madam Speaker. And I wanted to just address one of the comments that was made that the pendulum has swung too far in favor of employees. And I'm going to read to you a portion of the concurring opinion from Justice Paul Anderson in a case from 2013. He said, "When I first became an appellate judge in 1992, I believed that our jurisprudence was irrevocably and steadfastly headed down a one-way path toward ending sexual harassment in the workplace. I also believe that the policies of our state and the jurisprudence of our court, when implemented, would ensure that all citizens of our state, male or female, young or old, rich or poor, would someday work in a state where sexually harassing conduct is no longer tolerated under the law. I came to this view based on cases like Continental Can from 1980 and the legislative acts that followed that case. I was also much encouraged by the attitudinal changes I saw in the workplace. Yet, more than 2 decades later, as my service as an appellate judge draws to a close, I am concerned that the opinion the majority renders today signifies a step backwards on what I once believed was a one-way path toward ending sexual harassment in the workplace." So members, we aren't there. And many of us who, all of us who served in the Judiciary and Civil Law Committee heard testimony from a brave survivor, and her name is Amy. And I'm gonna, because not many of you were on that committee, I'm gonna tell you about the story that Amy shared with us about the sexual harassment she encountered recently in the workplace. Amy was a server at a restaurant for about 9 years. And one day when she went to work, some people that she didn't recognize, 2 men, asked that she serve them. And it was kind of strange, but after that, the men started coming into the restaurant at least weekly. They would always ask to sit in Amy's section. They told her they had a crush on her, even though they found out she had a boyfriend. And one night, neither man had come into the restaurant, and Amy got off her shift, and she went out to her car that was parked in the corner of the parking lot. And as she was about to sit down, a truck quickly approached her car, blocked her car in. One of the men from the restaurant had jumped out of his truck and left his truck running and the door open and started shouting her name. Amy, of course, was very alarmed, and luckily other servers were in the parking lot, and they kind of came to her rescue, and all 3 of them were fearful that Amy was going to be abducted that night. Amy told the men not to follow her to her car again. She was afraid they would even follow her home. Now, Amy reported this to management and the general manager and said that she did not want to serve the men anymore, and the management told her they had to because they requested her. Employees and even the managers at the restaurant started referring to these men as her stalkers. The behavior of the men escalated 2 more times. They stalked her in the parking lot. On one of those occasions, they had waited, the managers allowed them to wait inside the lobby for 2 hours until Amy started her shift. And then they came out, approached her in the parking lot, and yet management still made Amy wait on them that night. On another occasion, one of the men said he would drive by and see her car in the parking lot, so he knew exactly when she was going to be working. The behavior also became physical. He would pat at her hands and her arms as she put dishes on the tables. The managers saw it. She continued to tell the management she didn't want to serve them, and she was told that if she didn't serve the men, then her shift would have to end. Amy said, "The managers routinely made me choose between being able to pay for rent and food and being sexually harassed, assaulted, and stalked, all while calling these men my stalkers." The stalkers also tried to force hugs on Amy whenever they left the restaurant, and she would hide in the kitchen. She would have other servers try to take care of her other tables, but the stalkers would wait on her, and management would make her go out and say goodbye to the men and would watch to make sure that she did that. Amy, of course, saw that management wasn't going to do anything, and so she ended up getting an order for protection to keep the men out of the restaurant. And she told the general manager about the order for protection, but he refused to share that information with any of the other managers in order to keep these men out of the restaurant. So Amy at that point, and by the way, this harassing behavior happened for about a year, she said, at least weekly. So this happened over a long period of time. And eventually Amy did seek out an attorney, and they did file a lawsuit, but nothing ever came of it because it was dismissed on summary judgment, and the judge found that the conduct was not severe or pervasive. Members, Amy bravely came forward to share her story with us, knowing that any change to the law would not help her, but would help the next victim of sexual assault. By voting green today, members, we are taking affirmative action about the Me Too movement by saying no more. I appreciate your support. Thank you.
The clerk will take the roll on the bill. The clerk will close the roll. There being 113 ayes and 10 nays, the bill is passed as amended and its title agreed to.